So I'd like to open it up for the audience. Now, there are microphones here, I believe. Did Eric Doster put up some microphones for us that people can use?
I don't know.
Okay.
No, we could pass these.
Yeah, if anyone would, if you'd like to come up and use my microphone, please do.
I saw hands.
Questions? I thought somebody.
Questions, comments?
Maybe they could ask and you could repeat it, or.
Are you
Yeah.
calling on people?
Yes, go ahead.
Yeah.
Yeah, go ahead.
Okay, I really, really appreciated your comment, Jameel, Jaffer, about impotent facts and institutions that fail to reckon with those facts, particularly being here. And I have some comments that I would like to say because I found this discussion extremely fascinating. I feel that it's because of the so-called law, the legal memos that were so-called legal memos that created Guantanamo. And yet we seem to be in this situation where law that created Guantanamo cannot be used to dismantle it. And I agree with you what you say about impotent facts. We know all these facts, but nothing seems to happen. And I just actually, because I've worked in this area, my name is Sharon Adams, and I'm the National Lawyer Guild Committee Against Torture, and I just wanted to say some of the things and the institutions that have failed us, actually, because I think we should call it out. The Pennsylvania Bar. Some very students from this very school actually filed a complaint with the Pennsylvania Bar, which is where John Yoo is barred, and it was completely dismissed. No comment at all. We, the National Lawyers Guild, filed a complaint with the State Bar of California against William Haynes, and that went all the way up to the California Supreme Court and was likewise completely dismissed. So, Professor Cole, you mentioned the ADA, but the state bars have done nothing when they've been asked to do something. The OPR report, which I'm so thankful was mentioned because it's an extremely elucidating account of exactly how bad John Yoo's legal scholarship really is. And I say that here in this law school. And it is astounding that one person, David Margolis, was able to completely revoke and eliminate that great work that's in the OPR. That's another institution that failed us. And of course, another institution that I just must mention is Berkeley Law School. Because here we are, where John Yoo is not only allowed as a professor, and no investigation of any sort has ever occurred, but he has been, in fact, rewarded with an endowed chair and the co-chair of the Korean Law Center. So it's not just that he's like allowed to sit off in some corner. He's being rewarded and promoted for what he did. And I put forth, and I have said this before, that what this law school is teaching is that if you serve powerful interests, you will be protected. And that is what is being taught here. And I have to say, and I also have to say, just regarding sort of comments regarding deciders versus advisors, which was sort of being discussed in a way without using those words. I just want to say, I believe it was you, Professor Danner, that said advisors can tell what they can do, what clients can do, but not what they should do. But in fact, John Yoo didn't tell what we as a society can do. He said what we could not do. He told us to do things that were illegal. So I don't think that we need to be deciding whether it was John Yoo or George Bush that did it. No, John Yoo gave the advice. The OPR report has detailed how it was so wrong. And I really, what I'm trying to get at here is, I believe the Senate report that just came out is an opportunity because we have finally seen the New York Times come out and say prosecute. We've seen Chemerinsky say it.
Yeah.
You guys have ability within this school to do something. It's got to start somewhere. We can't just keep passing the buck. And
Okay, so maybe panelists would like to respond? Would any panelists like to respond to this or comments?
Well, are you asking whether we could do something in the law school about? Well, there are two levels of this. There is a personal political level where some of us have done things.
I understand.
They may not be visible, and they may not have been successful. I think that myself, I've been very disappointed in the response of the law school faculty and the student body. Been very disappointed in the student body. And they haven't shown up for this panel, for instance, in numbers. And but that's a small point. They take John Hughes courses. A lot of them think he's a good teacher. So I've been very disappointed in that personally. You know, I mean, I'll just say that.
I think you know it's not my time. I just want to say in response to the students, I personally feel that when the institutions such as the Congress, the bar associations, and the law school, and the professors themselves don't take a position, why do we expect students that are incurring hundreds of thousands of dollars of debt?
Well, this is.
Okay, let
Dr. Cole finish.
A good point. I think the faculty should certainly be the leaders if people are going to take positions. I can't defend them. They're not taking positions. People have done small things, I guess I would have to say. So that's one level. That's just a personal political level. On the merits of it, there are no really clear public standards whatsoever in the university on what you'd have to do to get a chair. And so there are two views. The view that the school took is, and I think a lot of people in the school agree with it, faculty, is that a chair is just another promotion. It's just a raise. You do a certain amount of work, you publish a certain amount of stuff, you get a raise. If you get to a certain level and you publish something more, you get a chair. It's not, they don't look at it as a representation to the public and to ourselves and to other academics of the quality of the candidate in terms of all of his professional work and of both the integrity and the quality of all of his professional work. Now, I think myself, I've always felt that a chair represents that to the public, that we say this person has got full integrity, both and competence in everything he does that's professional. It's clear that that's not the interpretation that the people who make these decisions have taken. I think it's a terrible mistake.
Can we have other questions or comments? Oh, yeah, go,
Yeah, I just wanted to say, you know, this is a fascinating subject and a painful one. You paraphrased a remark of mine that actually wasn't a remark of mine. It was Philip Zelikow who said that about we asked lawyers what we could do rather than had a debate about what we should do, which I think is quite accurate. I also think, you know, there are moments in history where the wing of history sort of comes down and touches somebody or some institution, and very often it's not a very comfortable position to be in. And that happened over the last decade when it comes to this institution. The wing of history sort of went boop, and I think the institution was found terribly wanting. I think the OPR report is a remarkable document that serves itself as a very clear investigation of what exactly happened and what were the legal and moral choices of the key people involved. And I think those conclusions are persuasive and in some ways definitive, despite what Associate Attorney General Margolis, I think he's Associate Attorney General Margolis, did in essentially rewriting it. And I think it's a great pity that there was no process started here, whatever its conclusions might have been, that would have borne some scrutiny in what is, after all, a moral, academic, legal environment that supposedly should be able to judge such questions. You know, the few questions are more important than this one, than the decision to torture and then its legal permission that was given by not only one lawyer, but a professor and at the end of the day, a law school. So I think it's a very sad and very painful thing.
One of the sad things for me is that we have a faculty code of conduct, and it's very general and vague, and then it gives examples, concrete examples of violation of the code. And so the only example that's really relevant here is a provision that says One example of your breach of your duty to the community would be conviction of a crime that shows you're not qualified, not fit to be a member of the faculty. So it said, it's an example of, in the code, it's an example of the application of the general principles. And the code says, as an example, conviction of a crime that shows unfitness to be a member of a faculty. So now, those are only examples, so you don't, it doesn't follow that you have to have a conviction.
Right.
It might be reasons why a person isn't prosecuted, but it would still show that he has violated this code. What I was sad about was that nobody made an effort to ask the university council what this language means. It was never, to my, and if they did it, it's a secret. To my knowledge, they never did it.
This woman would like to make a comment or question?
I would, I have much appreciation for this panel. I'm very, very glad it's happening, and it's happening right here. I'd like to say, thinking about Rebecca Gordon's talking about wedgies. I'd like to think, one, have people done enough to record the testimonies, thinking about the voices of prisoners, of those who have been released, who are no longer held by the government? Could our schools of journalism perhaps make an effort to hear more of those ones? But more important, I think, is the question of accountability, which came into the title of this panel, and that is, I know that we have not done enough in my profession, psychologist, to de-license and
Yep.
go after in
Mitchell and
professional
Jesser.
credentials of the psychologists who've been involved. And there's also been medical people and nurses that have been involved with torture programs too. But psychologists particularly have been part, as you have mentioned, of the question of accountability. And third, we've heard very well about the lawyers, and that's what we've been hearing most about here, and I agree. Have we been done enough, not just on the question of what schools should do, and professorships should do, but what they should be with whether they're allowed to practice law, whether they're debarred. And I would suggest that law schools and psychology and medical schools could go after this on the question of ethics and on the question of the license.
Comments?
Well, as the questioner, the last questioner said, the Office of Professional Responsibility actually recommended in its draft report that the case of Professor Yu should be brought before the Pennsylvania bar where he is admitted. That report was then edited at the political level, I think it's fair to say, of the Justice Department, where that recommendation was excised. So there was no formal process when it came to the bar, and she also pointed out that complaints, direct complaints to the Pennsylvania bar and to the California bar regarding another person, Jim Hayes, another lawyer, met with silence. I think your suggestion about getting the accounts of people who have been released is a very good one. Some of those people have written books. Moazzam Beg, for example. Mohamedou Old-Slahi is still imprisoned, obviously, and has written quite an extraordinary book. But I think if there were a systematic account to collect a kind of oral history would be a very useful thing to do. It is true that probably the people who have met with the most relentless examples of torture, most of them are still in custody, I would say. I mean, some have been released, but most of the very, very serious cases of people who were originally in the black sites and are now in Guantanamo are still at Guantanamo. They have not been released.
But everyone has stories to tell if they've just been there. Many of those sites.
They do indeed.
May I say, too, about nurses specifically, I think one of the things that we need to do is be lifting up the stories of people who did not panic, people who actually were able to say no. And I have a little article out right now that lists 6 of those, including Admiral Mora, and also Antonio Taguba, who lost his career in the military for doing the report. But there is also a Navy nurse right now who in July of 2014, refused to participate in force feeding in Guantanamo. And as a result, he was first threatened with prison, with actually being court-martialed. The Navy has backed off on that. They're not going to court-martial him, but they're now looking into whether or not they're going to give him a dishonorable discharge, which would mean that he would lose all of his health benefits, his education benefits, his pension, any of that. And yet, he's not named because his attorneys, because the thing is still in process, and so his attorney has said he should remain anonymous at this point. But he is not the only one. He's just one that we happen to know about who have said no. And I think this is an important point when we talk about panic, because in fact, the way the Convention Against Torture is written, it has a clause in it that says specifically no civil emergency, no case of war, basically no situation of panic counts as an excuse, will count as a legal excuse for torture. And so, in fact, the fact that there are people who were able, even in a moment of panic, to say, no, I'm not going to do that, I think is really, John Kiriakou is another one. Now, what exactly he did within the CIA has changed a little bit, the story he's told in the beginning and the story he tells now, but what he clearly says is, I refused to be trained in the techniques, and I walked away, and eventually I, in fact, revealed them to the public. He wasn't panicked.
This gentleman here.
I have a question for the panel, except Rebecca.
Okay.
One of the things that I think that didn't necessarily get addressed here about how the acceptance of torture has gone up is marketing and PR. They have a better marketing and PR people. I mean, how many of you have been called and asked to go on the national TV shows to talk about torture right after the Senate report came out? I mean, did you get like NBC on the phone and say, I got to talk to the head of this slide? There is a total disparity in terms of how people who are going to talk against torture or even against war are going to be talking to the media. And right now I've worked with Rebecca and I'm working with John Kiriakou, which is he's now out of jail, and he was an hour-long interview with Democracy Now! So many of you might have seen that. So I asked some of the people, I said, so are you going to, does he get to go on the TV shows, you know, right after somebody from the CIA says we don't torture? And he says, well, he's under house arrest, and if the media sends out, you know, some people, maybe they could, you know, interview him, but there's nobody who is, you know, actively pushing the legal scholars against torture on the media, the ethical scholars like that who can counter this message that says, oh, it isn't effective, how do we know? And the weirdest thing, the most interesting thing I found out recently from John was, did you know that there's a propaganda department within the CIA that actively has been releasing information to the media saying, oh, torture works, let me give you an example. And those are lies. They're falsehoods. And John revealed that. So an entire department, a marketing department, feeding the media lies, and the media accepted them, and they didn't even say who it came from. So my question for you is, how can people help get you guys in front of the media?
Well, first of all, I agree that the CIA has a fairly effective lobbying arm, and this was actually shown in the Senate Select Committee on Intelligence report, how disciplined they were in getting out examples of torture supposedly working and how elaborated this program was. And also you saw once the report itself was released in December, there was a highly concerted effort, mostly on the part of ex-CIA officials, but high officials, like General Hayden, for example, to get out onto the networks and defend it and trash the report in a way that was extremely effective, mostly because they would not read it. And very few of the interviewers, I remember actually Cheney on Meet the Press, very few of the interviewers would ask specific questions about specific conclusions. So it was enough essentially to get on the tube and say, well, this is, as Cheney very eloquently said, this is full of crap. He said, the report is full of crap, our ex-vice president. said. Having said all this, I don't think, my impression is there is not a lack of people in the public eye criticizing and talking about torture. I mean, I spent an awful lot of time doing it for an awfully large number of years. And, eventually you kind of need to get some work done. It's very, but it's time consuming. And I'd like to think that what is happening here is a PR battle in which the sort of torture proponents are winning. But I don't really, not only that they're winning, but that they're using secrecy and people don't know and so on. But I guess I've really changed my view over the years. And we're talking about a decade now. I've done 2 books on torture. I've written a lot about it. And that is that people do know. The information is out. And one can continue this kind of public debate. But I have to believe that it isn't lack of information that's causing people to have the opinions they do. It has to do much more, I think, with fear and also with the narrative, erotic power of torture itself. That is the kind of scenic power of torture, and the also notion that it in some way satisfies some vengeful instinct in people. The idea that these people are being punished like this and so on. I think they're rather dark impulses at play here. And having said all this, I agree. I wish more people were out giving the information that you're saying. I just don't think really, I guess, that that's the essence of it.
Other comments? This woman in the back, green, in the green.
On this campus, just a few years ago, there was an effort made to have the academic senate look at the question of academic freedom, which is the basis on which the question came up through the ranks, through the law school, and was possibly the message given by the University of California, Berkeley, on its homepage, gave the apologia, if I may say, for keeping someone who had not been convicted of a crime. There was a roster of members of the Academic Senate on campus who came to meetings with the head of the Academic Senate here, and we were prepared through one of the honored scholars, Brad DeLong, actually prepared a resolution saying, to go to the Academic Senate, saying, we wish to have a subcommittee or a group investigate the question of academic freedom with particular reference to the case of John Yoo. And it was snookered at the very last instant in a May meeting of the Academic Senate. When it was to come up, it was suddenly removed. The Academic Senate doesn't meet again until September or October. I was part of that, and I would be willing to work with faculty here who would like to renew that effort to get the Academic Senate to help clean the escutcheon of this university from a very shameful continuation of acceptance, when in fact the issue of torture is up to and including the life of the nation. It cannot be done. It is non-derogable.
Right.
And that has been ignored, and I wonder why, and whether we can bring up that element of the argument which has elevated some people higher and higher, whereas our constitutional obligations with respect to rule of law have been dragged through the dirt.
And can you tell us who you are? Can you tell us who you are? You said you're what?
I've been teaching international human rights law and politics here. And
Rita Marin. Okay, wonderful. And you're willing to work with people on this. Wonderful. Thank you. Yes, this.
I'd like to leave out the Office of Professional Responsibility review of Mr. Yu's work. And I'd like to just suspend that and ask the two lawyers.
I know.
How does he defend his work? Is it defensible in light of the criteria that you laid out, Professor Cole? Is the legal reasoning acceptable or utterly unacceptable from a lawyer's point of view? Is the type of behavior that he engaged in the type of work that I've done on behalf of clients and argued on behalf of clients who've been, committed murders and rapes and robberies and what have you? How do I distinguish Yu's behavior, and how do I judge his work? And if the answer to that is it's not defensible, what's going on here?
Well, you want to go first? Or should I?
Well, I don't think anybody defends it as a piece of legal analysis. Even Margulies, who overturned the OPR, the Office of Professional Responsibility Report, doesn't defend it as legal analysis. I mean, it omits. It's a memo that is in part about the power of the president to ignore federal statutes, and it omits the key Supreme Court case, Youngstown Steel, which involved the seizure of steel mills during the Korean War. So nobody defends it as legal analysis. I think that the harder question is, when does bad lawyering become unethical lawyering, and when does unethical lawyering become unlawful lawyering? And I think I will defer to Professor Cole on that one.
Well, as Jameel said, Margolis said this is unworthy of the OLC, this work. And it was withdrawn officially.
Yeah.
Those memos were withdrawn by a subsequent counsel, head of the Office of Legal Counsel. So I think that let's just on the ethical question, I said a number of things that I think ethically you should do. If someone doesn't do that, do I think he should be disciplined? I'm not sure. It just may be that some ethical questions have to be left as ethical questions. I'm not sure. This particular piece of work, and of course sometimes you are very partisan in your work, but as you said, you're representing a client in an adversary situation. These memos were not adversarial. They're very easy to distinguish, I think, from what you do in representing a client, because they were really about counseling and advising. And so it seems to me that we are left with a piece of work that's very, very bad and extremely harmful to the country. And one of the people responsible for it is on the Ninth Circuit now.
Yep.
The other one is a professor. And you were saying, well, what's going on here? I'll ask you. There's no answer to it.
Right. I mean, when I came in here, I went to the mentor when I was a kid, law student there. And I said, where's the room? And he said, blah, blah. And I said, this thing's going on. He said, oh, yeah, I hope nobody goes to it. Hope none of the faculty goes.
Really?
And as I look around, I don't know if there's any faculty here because
There were some, not very many. Is that what you were asking, Dick?
Yeah, I mean, is the student, is the law school involved in any way, or the faculty?
Did he say why?
That the students shouldn't be involved because how can we expect the students to be involved in light of the fact that the court isn't and the bar is as well? That didn't stop anybody in 1964.
Well, you as an old 60s type, Dick, you know that sometimes the students led the faculty.
Yes, exactly.
So it isn't always the case that
Exactly.
we need the faculty to lead, but it's just, I would say, that to me, it's an example of careerism. People have their jobs to do, they want to do their research, they want to study law. You just don't want, it's just not,
Well,
they're not
one
civically
thing
involved.
one thing I would say is that the ACLU every year gets dozens of law students who want to work with us on this set of issues. Maybe there should be more. I don't know, but it's not like there's nobody who wants to do it. There are a lot of people who want to do it. I think that there's a general frustration. There's a general sense of hopelessness that, or maybe cynicism. That there's a sense that there's nothing we can do. And you may disagree with that, but I think it's certainly an understandable outlook on the world, given what's happened over the last 13 years. And the other thing is, this set of issues, I'm not sure how immediate it seems to many of the law students. I mean, there's a new set of human rights abuses that they're talking about every day. In New York, where I work, people are concerned about police violence. They're concerned, to the extent they're concerned about national security issues, they're concerned about the drone program, they're concerned about surveillance. And I think that this torture issue is a hugely important issue, but if people are focused on those other issues, I don't think that I think it's understandable that people would be focused on those other things rather than this one.
Well, that's very.
We've got time for a couple more comments. This man's been waiting patiently for a while.
I'm Steve Bingham, and I'm class of '69 here. I wanted to just say a word from the discussion about alums of this school and what could be done, because it's been kind of shameful. And your comment just now about hopelessness, it's the first time the word's been used, but I really think that is what's permeating our society a whole lot, whether it's these kinds of things and Facebook and all the rest of it. But I so like that this discussion, which was so good and rich, really. I also like that the audience is sort of reaching out, what can we do? And we're right here in this very building where there's something that symbolically is hugely important. And I think ripples on the pond, if something happened here, it could actually permeate the discussion that you all have alluded to. It's this real Alice in Wonderland world where words don't seem to mean what they actually mean. And then it brought home when Bob said that distinguished doesn't mean distinguished anymore. It just means, well, everybody gets promoted, and that's kind of how they are. So I just wanted to let everyone know here we have a group called Concerned Bolt Alums, and it has an email, that name at gmail.com. And I think I got that right, but concernedboltalums@gmail.com. But people could come up to me, or Dennis right behind me afterwards and plug in. We definitely like to talk to you about concrete things that can be done. It isn't personal about this professor. It's very political, and because of all of the reasons that you all so eloquently laid out. The one thing that we have done so far in our modest way is we're a mix of people from all over the political spectrum who just somehow got the camel straw that broke the back, or whatever, was the distinguished chair. Yeah. Somehow we were willing to accept academic freedom, even though we disagreed with it for a lot of reasons. But when you make this guy a distinguished professor, and look at the website, everyone who hasn't done it, look at the website that has a link to when they gave these 6 people the distinguished chair. The university owns that word distinguished, and they are proud of it. There's no ambiguity the way it's set out. So here we have an opportunity. The one thing we did is to try to learn from the new dean what is the process that was taken, because this is after all a public university. It has a higher standard of transparency than a private institution would. And I'm interested to learn about the academic senate. seems like the kinds of transparency that I thought 1964 kind of brought us to doesn't exist. So we want to learn that process, and then we're looking for suggestions, very legal suggestions, in terms of dealing with this institution, where we might go from here, given that you're probably not going to get a whole lot of information, because they're going to say it's part of the personnel file and it's privileged.
Well, I think that the time for our panel to close has come, and I want to thank the audience for participating, and as you've been, and also the panelists. See you again some other time.